A lot of people think that having a will alone is enough. You sign a will and it says, I want my spouse to get everything or my kids get everything, and you think that's it. It's simple, easy, you put it on your shelf and you forget you ever wrote it. But at the end of the day, what a lot of people don't realize that there is major downsides to having a will. So the problem with the will, the major problem with the will is that your will does not avoid probate court. This is a major misconception that a lot of people fall victim to when they write a will and they somehow assume that by just filing that will with the county or bringing it to the bank, your loved ones are going to have immediate access to everything that you owned. But the truth is that sadly, that's not the reality. Your loved ones will need to file for probate court approval. They will need to open probate. They will need to follow the statutory laws in your state for administering probate. They will need to notify all of the beneficiaries, known and unknown. They will also need to notify all of the creditors. They need to publish things in newspapers. They need to go through months and years if somebody's contesting the will. So a lot of people don't realize that there is no automatic inheritance with the will. Another major danger of a will is that a will does not control all of the assets. Beneficiary designations and joint ownership override the will. So when you are creating an estate plan by saying everything goes to my kids, you don't really know what that everything will entail. Is it your house? Is it your bank account? Is it your 401k? Wait, no, your ex-spouse is a beneficiary on your 401k, so it's not going to go to your kids, even if your will says that it will. So again, a review of all of your financials needs to be a part of your estate planning conversation to make it an intelligent and actually comprehensive process. Just signing a will alone is not going to cut it. A trust, on the other hand, works very differently. With the trust, not only do you avoid probate, but you also have all of the specific accounts and assets that you own outlined in the trust instead of just saying everything and letting them figuring out what that everything means. The power of trust is that a trust becomes the legal owner of everything that you own during life. And so when you pass away, all of those assets are immediately available to whoever you name as your next successor trustee. They don't have to go to probate. They don't have to go looking for statements. They don't have to go searching for the assets. They don't need to go locate the deed to your house. Everything has already been pre-funded into this trust. So you're avoiding probate. Plus, with the trust, you also create privacy. So you can name your trust the ABC Trust and nobody really knows who owns it. And so you're creating that layer of anonymity while also avoiding probate and making sure that none of your assets actually get lost and that everything actually goes to whoever it's supposed to go to. Here's the biggest mistake to avoid with trusts. So they sound like they're a really good idea, and they are for, again, 99% of people that have families and assets. But the major mistake that I see happen is that somebody works with a transactional attorney who writes a trust for them, but they don't actually fund the trust with everything that they own. Trust funding is a term of art that we use in the estate planning world that refers to retitling every asset that you own into the name of the trust. For instance, you will need to write a new deed for your home that'll say that no longer Anastasia owns this house. It is now owned by Anastasia's Trust or the ABC Trust or whatever creative name you want to come up with for the trust. The same will apply to your bank account. You'll have to go to every bank, retitle all of the accounts. It'll also apply to your brokerage, your stocks, your bonds, your businesses, your rental properties, your life insurance, your 401ks, as far as beneficiary designations go. Everything that you own needs to be funded into the trust. I see a lot of people, I actually had a few today, that wrote trusts 30, 20 years ago, and they never placed a single asset into that trust. And somehow they're thinking that they're avoiding probate, but everything is still in their name. And so they worked with the documents only attorney who gave them a trust and never actually explained the process of trust funding. Another thing that I see is that some of that attorney sent CYA letter addressed to the client with the trust saying, hey, by the way, client, you need to go fund your trust. Here's how you do it. And then it's like an instruction of some sort. Again, in 99% of cases, you as the client are not going to do it. You're probably not even going to read that letter. You're going to receive the documents that you signed with the attorney and assume it's all been done, put it on your shelf, and again, forget that the trust actually exists and just think that somehow magically all of your assets are outlined in that trust. And so a lot of attorneys won't actually do the process of trust funding for you. We're one of the few firms that actually does it all for our clients. So we get all of the forms and we do it all with the client, and then we stay in touch with you for a few months after to make sure that everything's been done and that you've gotten proof from every financial institution before we put you on any sort of a maintenance program that we follow. But again, if you have a trust and now watching this video, you realize, oh, I actually don't know if my trust owns everything that I own, you probably need to go revisit the trust or meet with another attorney that's going to help you fund all of the assets into the trust. Because just by having a trust, you're not actually avoiding probate. All of the assets that are not funded into the trust will be subject to probate. So I hope that you found this video useful. Now you understand that a will alone is not enough for 99% of people, and that it is really important to work with an attorney that's going to help you retitle all of the assets into the name of the trust. And then also another tip, you need to work with an attorney who's also going to give you some ongoing guidance, because you will likely change some of the assets that are in the trust. So you may now have a house in Denver, and maybe in the next couple of months or years, you're gonna move to Centennial, Castle Rock, maybe even another state. So at any given moment, the house needs to be in the trust, your bank account needs to be in the trust. So if you're moving assets around, you need to work with a law firm that's gonna give you that ongoing guidance on how to retitle or add more assets into the trust. I hope you found this video useful. You can subscribe to our channel. Make sure you leave us a like, maybe a comment, and I will see you in the next video.